This time around, being a THJ supporter, I've spent the last few days, week, trying to find relevant cases that pertain or relate to THJ in some way that would give them a chance in court against Daybreak. This was done just for personal interest, but I just want to go over a few cases that I found that were kind of similar to THJ and what they face and the outcomes of that. Now, when I started this search, I was basically looking for a way that THJ could win the lawsuit. And I've read a lot of the comments and arguments in there. And the problem is there's so much legal precedent for these types of cases. So the first case you want to look at, and we'll call it case one, Blizzard versus Scapegaming 2010. Some of you might be familiar with the Scapegaming case, but basically it was a massively popular private World of Warcraft server, and it launched during the height of WoW's popularity, ran independently of Blizzard using the official WoW game client and letting players bypass Blizzard servers entirely. So at its peak, it had thousands of active players, and they all logged in using a custom tweaked version of WoW that offered, faster leveling and special perks. And then players could donate real money for in-game advantages, and Scapegaming raked in over $3 million in profit. So in 2010, Blizzard sued them. And then this is one of the major precedents that was set for private MMO servers worldwide. So the case facts, and all this is summarized, so I don't got the whole thing in here. So they operated a full private WoW server. They let players connect with Blizzard's original game client. The server altered gameplay, introduced custom perks, offered faster leveling, bypassed Blizzard's Battle.net login system completely. And then they monetized it through a donation system that unlocked powerful in-game rewards. So the lawsuit accused Scapegaming of copyright infringement for copying and distributing Blizzard's game files, DMCA violations for bypassing Blizzard's login/authentication systems, and unfair competition by running a rival service with Blizzard's own IP. And the court ended up awarding them $88 million in damages based on, and this is like real key to me when I read this, I had to read this again. So this statutory DMC damages that they did $200 per act of circumvention per user per instance. That is a minimum. It's the minimum by law. The judges have to order that if they find that there's been a DMCA violation. So what's $200 times 30,000 users for THJ? $6 million. That is the minimum amount of DMCA damages that a court can order if they're found to be in violation of that. And then profits Scapegaming earned from donations. So based on the statutory DMCA damages of $200 per act, and then the profits that Scapegaming had, they awarded them $88 million in damages. So if you're wondering why somebody would make an LLC before they started the project, it protects them from things of this nature for the most part. If you are found to be operating personally, privately, and unbusiness-like, they can pierce what's called a corporate veil and bypass the LLC and sue you personally. As far as Project Quorum, as I talked about in the last video and as Sandra talked about, Secrets did not have an LLC. So if a DMCA violation is to be found, it would likely be found also against Project Quorum and all emulation servers. And there is a minimum damage assessment of $200 per act, per user, per instance. That Scapegaming didn't even appear in court to defend this. This was the default judgment. And then legal experts did agree, though, that the outcome would have changed if they had. So how this relates to the hero's journey is, like Scapegaming, THJ uses the official EverQuest client and lets players bypass Daybreak servers to connect to their own. THJ tweaks gameplay, adds new systems, and monetizes through donations. It's the same behavior, basically, as Scapegaming. And under the DMCA, every user who logs into THJ bypasses a server could count as $200 per violation for each connection. And like I said, with 30,000 users, the potential damages are catastrophic. That is a minimum that they have to assign per violation. Okay, that's not the judge just coming up with a random number. So the Scapegaming case is a direct warning to THJ. If you run an unauthorized server using a company's game and monetize it, you'll most likely lose. That is the precedent that has already been set, and this happened in 2010. And unfortunately, most of the cases I have found, I did not find a single instance for anybody that was doing what THJ did where they won in court. The best was like a partial settlement or agreement. All right, so those of you that don't know, the DMCA or Digital Millennium Copyright Act can be pretty brutal when it comes to private servers. Basically, it makes it illegal to bypass any technological protections like login servers or authentication checks, even if you aren't copying the game files themselves. And it comes with, like I said before, an automatic statutory damages of at least $200 per violation per user, whether or not the company can prove harm or lost profits. That is in the act. So when a server like the Hero's Journey lets thousands of players connect every day by bypassing Daybreak's login system, those fines can pile up into the millions fast. As you've seen, even just the simple user count is pretty excessive. $6 million for 30,000 players at $200 if they all logged in once. Also, I just want to address this. Some people in my comments say that Daybreak could argue that they allowed other emulators before, so they gave up the right to sue. That's called the Laches defense, Laches. And courts have ruled over and over that copyright owners aren't required to sue every infringer right away. So ignoring other servers doesn't mean a company has lost the right to protect its IP, especially when the server in question is making money or directly competing. So at the end of the day, whether THG sees itself as a fan project or not, the moment they bypassed Daybreak's protections and distributed the game client, they stepped right into DMCA territory. So the next case we're going to look at, case 2 we'll call it, is Nexon versus UMaple. This happened in 2012. So UMaple was a private server for MapleStory. I've never played it. Just one of the cases that kind of relates to THJ. It's a massively popular side-scrolling MMO from Nexon. So it operated by letting players connect with Nexon's official game client, completely bypassing Nexon's own servers. Sound familiar? It had around 17,000 registered users. It was known for its donation system, which allowed players to buy in-game perks and advantages in exchange for real money. So this wasn't a hidden project either. It ran for years, advertised openly, and built a decent player community before Nexon finally dropped the hammer. So here's some of the case facts. UMaple let players use Nexon's official MapleStory client to connect to its private server. The server replicated Nexon's game environment, allowing players to bypass Nexon's official login system. UMaple also offered in-game benefits for real money donations, a classic monetized private server model. So they sued for copyright infringement, DMCA violations, unfair competition. The court entered a $3.6 million judgment against UMaple, calculated primarily under the DMCA statutory formula of $200 per act of circumvention per user, multiplied across nearly 18,000 users. So even though Nexon couldn't prove massive profits, the DMCA statute forced the court to award damages anyway. So even the judge in this case, I had to point this out, criticized the harshness of the DMCA formula, but said there was nothing that they could do by law. So they ended up defaulting, didn't fight the case, but the outcome likely would have been the same. So how does that connect to THJ? So like UMaple, THJ uses original game client, in this case EverQuest, and bypass the official login system. So that alone right there opens you up to the DMCA. THJ allows players to modify a version of the game entirely outside of Daybreak's control. They tie in game perks and quality of life features for real money donations, exactly what UMaple did. And the DMCA, once again, does not care if you're making huge profits or barely covering server costs. Each user connecting illegally counts as a violation. Although the judge was sympathetic toward UMaple and thought that those damages were excessive, that the courts have to enforce these laws strictly. Okay, the next case we're going to look at, case 3. And I don't know how many more of these I'm going to do. I have a bunch. But case 3 is important because the actual game was like dead. It like went dead. So case 3 is Atlus versus Relimagine, 2021 to 22. So I'm not going to pronounce half the stuff, but basically it's a fan-run private server for Shin Megami Tensei Imagine Online. It was a Japanese MMORPG. Atlus, the company, officially shut down in 2016. So after the shutdown, the fans revived the game by hosting their own servers using the original game client and files. And Reimagine project didn't just recreate the game and let thousands of players log in and play using Atlus copyrighted assets all outside of Atlus control. So even though the game was officially dead, the fan server lived on for years before Atlus finally sued in 2021. So this case showed that even bringing back a dead game doesn't protect a fan project from a lawsuit. So case facts, they let players download the original game client, connect to private servers that reproduced the full MMO experience. So they sued alleging copyright infringement, DMCA violations, irreparable harm to their rights, even though the game was no longer officially available. Lawsuit asked for $25,000 per infringement plus attorney fees. So that's the other thing about this. That $200 is mandatory minimum. So the company can actually ask in addition beyond that. These guys went for $25,000 per infringement and the permanent injunction to shut the servers down. So the court did not care that the official servers were gone. Under US law, even dead games are protected by copyright. No fan use or preservation defense applied because copyright holders have exclusive control over whether a game lives or dies. And I think that's really important because that's kind of the argument people are making, and in hopes that THJ can win this lawsuit. It has not been a valid argument in court. This case never even made it to trial. The servers went offline after the lawsuit was filed, and the project essentially shut down. So one thing I am seeing is that even though legal experts in these cases are saying it wouldn't have changed the outcome, the only interesting thing that THJ has is if they actually go to court with this, they might be one of the few projects actually challenging this. So I think whatever happens in this lawsuit, if they actually don't give up and close down, there might be a new precedent set. Maybe there's something that was missed or some way to bypass the DMCA and all these other things. But okay, so I had 7 cases lined up. We're going to skip to 5 because number 4 is just the exact same type of replica scenario where it ended in a default judgment. They didn't even bother to try to defend the case. So these ones are going to change a little bit. The next 3 are going to add little peaks, and there are going to be some partial wins, but not in the way you think. So this next case is case 5, Blizzard versus BnetD. This is from 2005 to 2006. So this wasn't a private MMO server like Scapegaming or UMaple. This is a fan-made emulator Blizzard's Battle.net service. So basically, a replacement server that let people play Blizzard games like Diablo 2 or Warcraft 3 online without using official Battle.net. So these guys are hobbyists. They didn't use Blizzard's code. So, okay, no Blizzard's codes. They reverse engineered the Battle.net protocol and built their own server from scratch. So they even released this project as open source purely for community use. There was one catch in this. The server let users bypass Blizzard's CD, key check, and other protections, meaning people could connect with pirated copies or without agreeing to Blizzard's terms. So Blizzard sued them, and this time the defense actually fought back in court. So case facts, they created online server functionality that bypassed the authentication process and CD checks. So Blizzard sued for DMCA violations and breach of contract because the developers had clicked Blizzard's EULA at some point, agreeing not to reverse engineer. So the BnetD developers argue that they wrote the original code, didn't copy Blizzard software. They believe reverse engineering for interoperability was allowed under copyright law. So the court ruled against BnetD, finding that even though the code was original, bypassing the CD key check still counted as circumvention under the DMCA, and reverse engineering isn't a defense if the result lets users violate protections set by the company. The developers were also bound by the EULA they agreed to. The ruling was upheld on appeal. BnetD lost, and the DMCA once again proved to be a legal wrecking ball. So we'll bring that back into THJ quickly. I don't want this video to be too long, but THJ bypasses official login, authentication, original game. We already know that. So even if THJ wrote original code or used open source emulation tools, it doesn't protect them if their system allows users to skip Daybreak's protections. So the BnetD case shows that you don't need to copy code to violate the DMCA. Bypassing access controls alone is enough to lose in court. So THJ operators are also bound by the EverQuest EULA if they ever accepted it, meaning they could face breach of contract claims on top of copyright and DMCA. And BnetD fought hard in court and still lost. So THJ's odds are even worse because they're using the actual game content, not just recreating, this was just network services they got sued for. All right, moving on to case 6. This one's a little bit different. This is third-party app/software. So case 6 is MDY Industries versus Blizzard. This is from 2008 to 2010. I know there's a lot of Blizzard lawsuits, but Blizzard was the big beast, one of the big companies that was able to go after people. So not a private server case. This is a botting program called WildGlider. So think of things like MacRequest. Third-party tool to automate gameplay in World of Warcraft. Players use it to level up, farm gold, run dungeons, not even being at the keyboard. Sounds like MQ. So the company that made Glider sold thousands of licenses for the bot software. They knew Blizzard's EULA forbade using third-party automation tools, but they sold it anyway, openly advertising it to WoW players. Blizzard sued in 2006, and this time MDY fought back in court. So the case dragged on for years and went all the way to the Ninth Circuit Court of Appeals. So here's case facts. Blizzard accused them of breach of contract, tortious interference, That's for encouraging players to breach their agreements with Blizzard, and then DMCA violations because obviously it bypassed their anti-cheat software. So MDY argued players owned a license to use WoW and could use whatever tools they wanted. Running WoW with Glider wasn't a copyright violation, just a contract issue, and Warden wasn't a real protection measure under the DMCA. The court's decision was mixed, but mostly favored Blizzard. The DMCA claim stuck. Bypassing Warden was ruled a violation of anti-circumvention laws, and contract breach wasn't enough to make it copyright infringement unless it involved unauthorized reproduction or distribution. MDY was ultimately on the hook for DMCA violations and had to shut down Glider. So they appealed and still lost on the DMCA point. So that DMCA is a bitch. That's all I got to say right now at this point. And we'll go one more case. So this case, again, is not like the first three cases that were about, using content and running your own service, stuff like that. But this is an interesting case here because it's also something that THJ could run into, and it might be something that could validate having a legal fund. So this one is case 7, we're calling it, and this will be the last case before I summarize it. And then hopefully we can come up with some theoretical defenses that THJ could use at the end when we bring this all together. But case 7 is Connectix versus Sony is from 2000, and Bleem versus Sony, 1999 to 2001. So unlike the other cases, these two are about emulators, not private servers. Connectix made a virtual game station, which is a software emulator that let people play original PlayStation discs on a PC. I think I remember this shit, actually. I probably used it at one point, but Bleem was a similar project, an emulator that ran PlayStation games on a computer. So both companies reverse engineered the PlayStation BIOS, but didn't include Sony's code or assets in their final products, didn't host games, distribute PlayStation content, or offer unauthorized versions to Sony software. Sony sued both of them anyways, aiming to crush the project before they hit the market. The defendants actually fought. In some ways, they won. So case facts for Connectix. The reverse engineered PlayStation BIOS, so its own code. Sony sued, claiming copyright infringement, unfair competition. Ninth Circuit Court ruled in Connectix's favor. Temporary copying for reverse engineering was considered fair use. Connectix's final product didn't include Sony's code, so it wasn't infringing, and the court acknowledged the emulator actually expanded the market for PlayStation games. Sony had to drop the case, and the emulator stayed on the market until Sony bought out Connectix. Case facts for Bleem. Bleem made a similar emulator, also requiring real PlayStation discs. Sony sued on several grounds: copyright, trademark, unfair competition. Bleem won key parts of the case. So the courts ruled that showing screenshots of PlayStation games for marketing was fair use. I think we hashed that out with World of Warcraft, where they claim they own screenshots and video content we made. They finally gave up that stuff. Remember, think like Joanna's leveling guide, and I had a gold guide out at that point. But the emulator itself wasn't infringing because it used original code and required users to own legitimate games. But here's the thing, where this legal fund might actually come into play. Sony kept the legal pressure on until Bleem folded from legal costs, even though Sony never technically won. If they don't outright win in court, in this case isn't even like really closely related to THJ. THJ is in a whole different boat, a whole worse situation than this. But just the fact that a company will keep legal pressure on running up those legal costs to try to collapse the company is something that could realistically happen. But as we've seen from the first three cases, it seems very unlikely that THJ is going to have a chance. I really did try to find something that would give them a shot. So let's go ahead and summarize this right now, and then we'll talk about maybe some hypothetical ways that they could stand a chance in court. To summarize, looking at every case we've covered, that's Scapegaming, UMaple, Relimagine, BnetD, MDY, Connectix, and Bleem, the pattern is brutally clear. If you operate a private server that uses the original game's assets, graphics, code, or client, and you let players bypass official protections or authentication, and especially if you monetize it, even through donations, you're probably going to lose every time. The courts have hammered projects like this with massive DMCA damages, $200 per violation per user, runs in the millions. Just the user account alone for THJ is $6 million. And the judges have shown almost no sympathy when companies go to enforce the rights, even if the companies have ignored the other servers for years. So laches, community support, or we're just fans, defenses don't work, haven't worked. And the law allows copyright holders to wait until you're big enough to matter and hit you then. And when it's a commercial competitor using the company's own game to pull players away, it's pretty much game over. So THJ operators are doing exactly what every losing defendant did before them. They distribute the full EverQuest client. How they get that, whatever. They have patchers that push this stuff out. They tell you to download it. They distribute the full EverQuest client, whether or not that's free on GitHub or whatnot. They bypass Daybreak's login and protection systems. Obviously, it's modified. We're logging to their server. We're not logging in to Daybreak. And they monetize through in-game perks tied to real money donations, RMT. We've covered that extensively. And they compete directly with Daybreak's live product. Now, I am thinking that the bar for that is substantially low. I think if they take a single player, if they can contribute one single player that THJ has taken away from the live servers, that alone is competition. And I'm sure there's a case that could be made to say that they are going to compete or trying to compete, or could be viewed as competition, even if they didn't take a single player. So there's not really any legal gray area here. They're most likely going to lose on the merits. So the only realistic outcome is they settle with Daybreak and shut down, or they fight, get crushed, and they face just massive damages, potentially millions. The best case scenario, before we get into any hypothetical defenses that might be so wild and impossible, but the best case is they negotiate a deal similar to Project Quorum or Project 99, stay a nonprofit, remove monetization, stick to the rules, and maybe they'd be allowed to operate under Daybreak's terms, but not being able to have that custom content, and I imagine there's going to be a lot of rules and demands that Daybreak makes. It's really going to change what THJ is and what made it popular and why I enjoyed playing it as many thousands of other people have. So what hypothetical arguments can we come up with for THJ to stand a chance in court? Stepping into the role of THJ's lawyer, an uphill battle. The first thing we want to be seen as not a competitor. So we are longtime fans of EverQuest. We want to preserve and celebrate a classic game experience that Daybreak itself they've moved away from it. You didn't create THJ to compete with Daybreak live servers, very important. And you focused on custom content, which is multi-classing, solo-friendly play, things that do not exist in the official game, and they serve a completely different niche. And THJ has zero intent to harm Daybreak's market. So basically we're fulfilling a role that Daybreak has chosen not to serve. The second thing we're going to try to do is show that we are not harming engagement with EverQuest. We are actually encouraging it. We can use examples like Project 1999 to show that fan communities can drive renewed interest in official content. So many of THJ players are also Daybreak customers. We've seen that over and over again in the comments. I'm a THJ player. I also have an active account with Daybreak. So THJ would serve as a gateway for new or returning players who would later migrate to official servers. So then instead of saying that we're harming Daybreak's market, we want to say that we actually are supporting it. So the third thing we're going to want to do is make THJ separate from the other cases based on commercial intent. So this is where we really need to show that we're operating on a true donation model, that nobody in THJ profited personally from THJ, that they didn't sell game-breaking advantages or exclusive content, and that the donation rewards were cosmetic or minor quality of life items. And you guys have known what I have said about the donation system and what I think on that. But the main point is that we want to move THJ closer, and I'm role playing here. I'm not affiliated with THJ anyway, but we want to move THJ closer to a non-profit fan project like Project 99, rather than cases like we went over with Scapegaming or UMaple. So the next thing that we really got to do, number 4, is we need to really attack the scope of DMCA claims. And we really have to push this, lack of commercial use. In a nutshell, the DMCA is meant to prevent against malicious circumvention. That's like piracy, cheating, or unauthorized commercial exploitation. So THJ doesn't distribute hacks or tools that compromise Daybreak security or authentication. And the modifications were community driven for personal use with no malicious intent. So we would be looking in this part here to avoid falling under DMCA, which is going to be really important. And then, as I said, it's an uphill battle. So the 5th thing we might want to do is actually offer some type of compromise in the hearings. This is where we would be willing to transition THJ into strictly nonprofit community supported server, removing the donation perks or anything that Daybreak finds objectionable, I guess, and that could hurt. and then comply with reasonable limits Daybreaks might impose. That's where you get those player caps and content boundaries, and that could really crush THJ if any of those are implemented. And then the sixth thing we could do is we're going to make an appeal to the public and community impact. There's basically going to say that there's a legitimate public interest in balancing copyright enforcement with fan community rights and digital preservations. In this part, THJ, we're going to say, serves a vibrant community of dedicated players who have no bad faith or intent, and that shutting down THJ could damage player goodwill toward Daybreak, which we have seen that overwhelmingly in the comments. People are going to cancel subscription, have canceled subscriptions. They're going to actively promote against Daybreak. Shutting down THJ will damage goodwill toward Daybreak and harm the overall MMO ecosystem, which EverQuest is kind of small anyways, so I'm not sure that it will harm the entire MMO ecosystem, but that's the type of route we want to take in this. The goal of this defense would be to avoid the DMCA damages. We do not want any of that. And to negotiate a formal agreement with Daybreak for continued operation. And then we could preserve THJ community in a way that respects Daybreak's rights but avoids destroying the project. It's an uphill battle, and I'm sure most of that stuff and more will be mentioned by THJ's lawyer in the upcoming court case. But I really wanted to find case law and precedent that would help THJ. I spent a little time running the legal stuff for my companies. Not a lawyer, but when you run your own company, you can fulfill any position you want within the company. So I couldn't find anything. So if there's something that I missed or a case you guys know about, I hope I covered everything. I think I covered most of the stuff that's been in my comments of how THJ has a chance in court. And I hope that this video has been informational to you. These type of videos aren't the most popular of my content, so I hope to get back to making regular content. I'm kind of at a standstill right now because I want to continue playing on THJ, but I'm stubbornly not willing to put any more time in until I see the outcome of this. And a few people hit on that saying, you know, you expected emulation servers to be protected. It's like, not really. But then when you look at Project 99, how long that's lasted, when you see something that is gaining traction in the community and is so good, you would think that it would last a little bit of time. I mean, Project 99 has been around for a while. So that's the video. Sorry it's long. Thanks for watching. And if you're interested in any more of my content, check out one of these two videos.